All right. Time. So it's time. I would like to start on time, so we won't be running late in the end. Welcome to the session on legal philosophy and its hidden dimensions. We have three speakers who will present very interesting insights and thoughts into different aspects on and around a law as such. So I'm really looking forward to this session. We will start with three presentations, each lasting 20 minutes. So if you have thoughts, ideas, questions, remarks, put them down on a piece of paper or on your computer, so we can have the discussion in the end. So we have 1 hour discussion, and then we'll have another half an hour to this 1 hour presentations, and then a half an hour time to discuss amongst us. To start, I would like to introduce Elina Mustaira, who is a professor of comparative law and deputy dean of the Faculty of Law of the National and Kapodistrian University of Athens. She is also member of the Supreme Specific Court. So she brings, and I think that will be interesting in her presentation, she brings an academic perspective, but also some practical insights on the many facets of law. Without further ado, I'd like to hand the floor to Elina, please.
Thank you, Lucas. I shall try to speak 20 minutes. If I see that it's bigger than that, I shall omit parts or I shall stop right away. So I don't have a PowerPoint, but I shall speak. I prefer to read on camera and not on my looking down on my paper. So perhaps it's better this way. So I shall say the subtitles: facts, reasons, and excuses. Communities of people in all times made law, used law, exploited law. There is no community of people without some kind of law, as Sacco rightly insists. Countries, especially when willing to become empires, try to legitimize their acts by laws and legal concepts, especially created to that aim. Economic powers of today follow the same path. Law is or should be reflecting the mentality and the specific characteristics of each human community, of each state, we comparativists point out. Probably or obviously, this is of no concern for the power holders. Is law just? Can law be cruel? Who will be the judge of it? Can rulers of one country intervene in the affairs and the law of another country? How did they do it in the past? How do they do it today? May they claim legal concepts in the name of which they could order another country to change its law, presumably unjust? Colonial past. How did conquerors use the law in their favor? A law which was far from what could have been meant as justice. It is not feasible, obviously, to speak about all the colonizers and all the facts that would answer to that question, so it is unavoidable to focus on a few very clear examples. How did the British behave towards people European and Asia conquered or acquired, to use an euphemism, lands? Let's see some details concerning the use of law in Ireland and India. Divide et impera was always the way. In Ireland, English elites worked out the politics of difference and subordination. To choose an example in time, let's say that in 1541, the Irish Parliament passed a statute declaring Henry VIII to be king of all Ireland, and the Irish, his legal subjects, bound to him in the same way as the English. Intermarriage was forbidden, as was learning the Irish language or adopting Irish modes of dress. English Protestant magnates founded the so-called plantations in Ireland, bringing Protestant settlers towards the end of 16th and beginning of 17th century from England, Wales, or Scotland to become tenants on these large plantations. The reason that the government and the Protestant elite put forth was that these plantations would not only enhance agricultural production beyond the capacities of the considered as backward Irish, but civilize them as Roman colonization had civilized the Britons. Their aim at putting English or Scottish settlers on the land was that Ireland's Catholics would not anymore have genuine rights or attachments to land, that they would be like the nomads that so many empires scorned. During all time of Elizabeth's reign, native Irish landlords resisted to those plans about their lands and to the introduction of judicial officers as representatives of the legal order. That resistance, as it is pointed out, revealed an operative gap between theory and practice and between two legal concepts, dominium in the sense of possession and imperium or sovereignty. According to the English crown's theory, it, the English crown, had a claim to dominium through conquest. It had no imperium, though, in most parts of the island. The process of colonization chose a brutal solution in order to diminish the gap between the two. It adjusted dominium through a process of confiscation and redistribution. Ownership of the land was reinvested in the crown and afterwards granted a new English settlers who would carry English justice and sovereignty with them as part and parcel of their tenures, as they said. English common law intended to replace Gaelic Brehon law. Convenience was the critical term, a term borrowed from the sphere of judicial and especially statutory interpretation, a term and its connotations and misunderstandings that would be steadily used directly or indirectly by the judiciary in all colonies of England in order to not be convinced about the existence of a local rule and to fill the, inter brackets, void with a common law rule. This was very clearly represented in the work The Fairy Queen of Edmund Spenser, himself too an undertaken in the first Munster plantation from 1585 to 1598, and a minor official in the Irish colonial government. This was law. Was that justice or just a coercive violence of interpretation that erased the force of alternative jurisdictions? Legal concepts were used then and always to give a foundation to the conqueror's aims. Interpretations were adapted to the conqueror's interests. In the above case, as in other cases too, theory was in the service of the crown. India is perhaps the saddest example of how colonialism contributed to the presentation of cultures and legal cultures of colonized people in a distorted way or in a simplistic, far from the truth narrative. An example of this was that the British magnified the problem of caste hierarchy in India following various methods for various ways. When Governor General was Warren Hastings, he hired 11 Pandits, Brahmin scholars, to create what became known as the Code of Gentle Laws or the Ordinations of the Pandits. As the British could not read or interpret the ancient Sanskrit texts, they could not check the work of their Brahmin advisors. The resulting output was an Anglo-Brahminical text that arguably violated in both letter and spirit the actual practice. Just a minute, because excuse me for the interruption. for the interruption. So as I said, the resulting output was an Anglo-Brahminical text that arguably violated in both letter and spirit the actual practice. In letter, because it was imprecise in regard to the originals, and in spirit, because the Pandits took advantage of the assignment to favor their own caste by interpreting and even creating sacrosanct customs that in fact had no shastric authority. Theory was also in the service of the European and later American too expansion, as Mattei and Nanda have pointed out in their book, Plunder, When the Rule of Law is Illegal. John Locke in England in 1698 and Émeric de Vattel in Switzerland in 1797 articulated plunder by means of law. As much land as man tills, plants, improves, cultivates, and can use, and the idea of terra nullius, lands which presumably belongs to no one and thus can be allocated to the powers that be. Variations on a theme, subtitle. Were all European colonizers' attitudes the same towards the conquered people and their laws? No, several scholars answer. For example, it is stated by certain scholars that there was a strong legal presence of indigenous people in Spanish America, while in British America there was a relative legal absence of them. Still, when one reads, for example, that in 1558, Jesuit Manuel da Nóbrega noted that in Brazil it was widely held that the Indians did not have full rights before the law because, lacking a soul, they were not fully human, one is not really convinced about the truth of the above statement. It is also claimed that the French followed a policy of cultural assimilation, so that, for example, children in Senegal or Vietnam learned to recite Nos ancêtres les Gaulois. Still, the following example does not really verify the above claim. When Algeria was occupied by the French on July 5, 1830, there was an intense administrative activity which culminated in a massive dispossession of property rights of the city inhabitants. The colonial jurists who wrote about that insisted on the hypothetical need of the French authorities of that time to diminish the big difference between the two legal regimes. However, documents not fully explored about this perspective show that the real reason were the conflicts about the property and the conditions for its access following the conquest. On the other hand, the British had a particular talent for drawing ethnically based administrative lines in all their colonies. For example, Indians were always subjects, never citizens. Law can form and transform. Obviously, one thing is certain. In no case were people in colonies really considered equal to colonizers. Slave law, but there were also the slaves, mostly people from Africa transferred to the American continent by the respective colonizers. And there were codes created for the slaves who were considered less than persons. In Barbados, an English colony, in 1643, there were 18,600 white colonists and 6,400 African slaves. In 1680, less than 40 years afterwards, of the total population on the island of around 60,000, almost 39,000 were African slaves. They were mostly the property of the largest 175 sugar planters, who also owned most of the land. Of the 40 judges and justices of the peace on the island, 29 of them were large planters. In 1661, the Barbadian Assembly passed the first comprehensive slave code in the English Americas to, inter brackets, better manage its profitable but unruly slave society. The title of the act was An Act for the Better Ordering and Governing of Negroes. Among its rules was one that stipulated, clause 2, that if a slave ran away or misbehaved, he was to be severely whipped, his nose slit, and be burned in the face. And there was the infamous French Code Noir, first promulgated by Louis XIV for his possessions in the Antilles. It was one of the most infamous and important codes in the history of French codes, says Vernon Palmer, who accurately points out that the code should be regarded as a sociological portrait, for no legislation better revealed the belief system of European society, including its fears, values, and moral blind spots. Facts and laws were interpreted in ways that could and would legitimize, inter brackets, the unjust behavior of the colonizers, and would award them with more power, more lands, the winners of wars, presenting them as saviors. That is what happened in Paris Conference of 1919, after the end of the First World War. The mandates and the League of Nations injected new subtleties into notions of sovereignty and expanded ideas of the responsibility of civilized, inter brackets, powers developed at earlier conferences. Only in retrospect do these changes appear as steps toward the dissolution of empires. In their own time, they added to the territories of some empires, 1 million square miles to the British Empire alone, enforced the legitimacy of administering dependent peoples, and reaffirmed that not all polities were equivalent in international law and practice. Colonial present. Are systems of colonial rule and economic exploitation a thing of the past? Nietzsche, in the Genealogy of Morals, sought to demonstrate how modern moral values are predicated on truth claims that distort the relationships between causes and effects. Gregory, in the Colonial Present, reveals how the dominant discourse of counter-terrorism is founded on a metalepsis in which the terrorist is presented as the cause of violent counter-insurgency and the complex and overlapping histories of imperial interests that produced such acts of violence are effaced. The language of law. Law can be used by rulers, be it states, be it empires, as a means to expand, to weaken rivals, to liberate, to subjugate, to fortify itself, to fortify its economy, to fortify its citizens. Law can be mobilized in various causes. It can be mobilized by multiple actors in their own, often opposed to each other, interests. Institutionalization of law has offered in the past, and it can always offer opportunities both to rule makers and to rule users. Legal pluralism in the former empires often meant something more complicated, even darker, than recognition of more sources of law. More than one legal fora were connected to local practices and legitimated by a superior authority. As it is mentioned, coexistence of multiple sources of law, customary, religious, of a prior polity, devolved authorities, the emperor, etc., combined with a multiplicity of instances for obtaining legal decisions, meant that justice was not just a moving target, but a many-centered one in any empire. The same could be observed today. Law can be mobilized by multiple actors in various causes. Different legal systems, all created and formed on the basis of various influences, either desired or imposed, mobilized law according to the aimed results. Comparativists can easier than other scholars understand why and how that happens. They can or should be able to see the obvious and the less obvious in legal systems, having in mind the respective sources of law and the permitted modes of law's interpretation. The administration of justice must serve the interests of society, it is said. This was always said, though, but the interests of society were and are considered differently in various times and various places. Is there a unique way to interpret the law? Comparativists would obviously say no, since there are many and different laws in the world and for a reason, or for more reasons. Law is not only the written one, so for a comparativist, the exclamation of Napoleon when confronted with commentaries on his civil code, mon code est perdu, would only be an element to study in order to understand the legal mentality of France at the beginning of the 19th century, in order also to understand the reasons for the French civil code's expansion, influence on other civil codes of the world. A comparativist knows that there are more reasons for all influences, copying, reception, transplanting of laws than the obvious. Often the non-obvious reasons are much more important. Politics is the word. I omit what I have written about legal transplants in order not to delay you. And I go on. Law should be just, says Waldron. Naturally, the law should be just, says Gardner, but it should also be honest, humane, considerate, charitable, courageous, prudent, temperate, trustworthy, and so on. People treat certain concepts as identifying a value or disvalue, but disagree about how that value should be characterized or identified, Dworkin argued. The concept of justice is one of those concepts. People agree that this is a value, but they do not agree about its precise character. People do not agree about what makes an act just or unjust, right or wrong. And this is most obvious when one studies and compares many and different legal systems. So are moral concepts interpretive concepts, as Dworkin claimed? On what does the validity of an entire legal system rest, asks Frederick Sauer. We know that laws are made, he says, we know that laws are made valid by other laws, and those other laws by still other laws, and so on until we run out of laws. But what determines the validity of the highest law? What keeps the entire structure from collapsing? And what about the indigenous legal systems where there are no written laws? And what about the legal systems of the former colonies, now independent states, that have copied Western laws and at the same time have recognized directly or indirectly their indigenous people's laws as equally applicable, at least at certain issues? What determines the validity of those legal systems? Which is the highest law and what determines its validity? If their highest law is a legal transplant or some Western law, what sort of independence is it? If the validity of those indigenous laws is determined by a legal transplant that has become the country's highest law, on what does the validity of such a legal system rest? The argument about a freely decided legal transplantation would not be so solid. Who decided about that? How free was such a decision? Although one would doubt whether Sauer considers the rule systems of indigenous tribes as law, Sauer himself would cast doubt on that doubt, since he declares, accordingly, we may again learn more by observing just how much non-state organizations betake of law or simply are law than assuming too quickly that they are not. Law has many facets. The conversation between law and justice is still on the road, and the road probably has no end. Thank you, and forgive me for the 2 minutes more than I should have spoken.
Thank you very much. I think you managed very well to conclude, keeping within the time constraints that we unfortunately do have. I think it was a wonderful journey through the past and the present and geographic. So I think it will be I'm looking forward to discussing your paper and your thoughts. And I'm quite confident that the next presentation will link up very nicely. So I'd like to invite and present Fabrizio Sciacca, who is professor of political philosophy and also professor of human rights. So he brings the philosophy and philosophical and the legal dimensions to our discussions. He is based at the University of Catania at the Department of Political Science, and he will be presenting, I think, I don't need to say more, I just hand the floor to you, so we spend more time on substance and less time on the form. Fabrizio, the floor is yours.
Thank you. Thank you very much, Lucas. Do you hear me? Okay, fine. I'm very happy to be here. And my paper, yes, my paper has maybe a lot to do with problems of political and legal philosophy. My paper concerns the relationship between archetypal structures and the so-called myth of law. And this consideration seems to me to be compatible with the idea that the structures of each society are archetypal structures, constant elements in the history of culture. So, I think I'm going to divide my paper into three parts. The first part is what are myths? Second part may be intra-historical nature of myths. And the third one is societies and archetypal structures. So let's start with the first part. What are myths? The collective imaginary is to be understood as referring to all the symbolic elements and above all from the bond that it establishes between familiar realities such as norms, traditions, narratives, and identity on the one hand, and the deepest symbolic structures on the other hand. According to Gérard Bouchard, the collective imaginary does not coincide with the concept of culture because it does not refer to everything that a society produces and through which the members of a society give meaning to their lives. In essence, the concept of collective imaginary is less generic and more demanding for Bouchard than, for example, Charles Taylor, the Canadian philosopher, political philosopher Charles Taylor, according to whom social imaginary is referred to as the way in which individuals live their lives. So my thesis is, my starting thesis, that myths are key elements of the collective imaginary. Myths are key elements of the collective imaginary. As Gérard Bouchard pointed out, all myths and symbols are social in that their emergence is always a product of a collective life. End of quotation. This means that social myths can be, in particular, better understood, emphasizing not the overall societal dynamic, but more specifically, the role of the actors, their motivations, the power relation in which they are involved, their strategic operation, and the concrete, immediate issues associated with them. To better highlight these particular features of the social myth, it can be useful to situate it in relation to other types of myths. For instance, religious, philosophical, allegorical, scientific, and so on. Certainly, social myths are part of a collective dynamic between four components: collective imaginaries, the social actors, the target population, and power relations and struggles. So my contribution comes about from the problem of social myths, as I said. Linked to this structure is the distinction between master myths, I think this is a relevant point, and derivative myths. Master myths have a strong consensus, or perhaps a stronger consensus than derivative myths. Whereas derivative myths are often subject to division and controversy, master myths serve to make societies stable and change slowly, take the form of fundamental symbolic devices that act as matrices, structure the culture of a society, and govern the formation of other myths. The derivative myths, instead, change faster, have a propulsive structure, and allow society to transform itself. The social myths would thus have a paradoxical capacity to be both enduring and ephemeral. In this sense, the collective imaginary is appropriately defined as a pyramidal structure comprised of a stable layer of master myths and a layer of secondary and derivative myths, periodically redefined in accordance with contextual changes. The idea according to which the myths as functional to social transformation generate energy rather than lethargy is also acceptable to me. In this sense, the myths have the power to generate emotions that serve to consolidate shared social equilibria. Thus, if master myths can concern social projects such as collective emancipation or a dream of national independence, they may well consist of tendencies toward justice, democracy, or equality. So, fundamental categories of law and politics. Already David Ketzer had supported the importance of a symbolic ritual structure and so as a strategic assumption for national myths. On the other hand, as Bouchard himself observes, since the derivative myths are subject to division and controversy, they can incorporate different visions of democracy, justice, or equality. In this kind of pyramidal structure, for every master myth, there exist at least two derivative myths. A first point is therefore the following: between master myths and derivative myths, there could be the same difference between myths that create consents and myths that create divisions. In essence, it seems to me that the difference between master and derivative myths incorporates that between concept and conception. And perhaps in this regard, it could be as valid as that between concept and conception of democracy, justice, and equality. Whereas democracy as a concept is a master myth, a founding myth of society, and therefore with an original symbolic potential aimed at aggregating consensus. Democracy as a conception is instead a derivative myth, which serves to nourish the differences of worldviews and thus to all of social changes. Examples of derivative myths of democracy could be the overlapping Konsens or overlapping consensus of John Rawls, the maximization of the utility of Jeremy Bentham, democracy as a minimal state and respect for negative freedoms, according to Robert Nozick. Of course, I'm referring to Nozick's anarchy, state, and utopia. Basically, I think that between concept and conception is a distinction between stable and changeable, between principles and interpretations, which can be applied to that between master myths and derivative myths. And this analogy can be grasped by quoting John Rawls himself. The concept of justice I take to be defined, Rawls says, then by the role of its principle is in assigning rights and duties in defining the appropriate division of social advantages. A conception of justice is an interpretation of this role. So another question is whether the myths are positive or not. Frequent changes to the level of derivative myths are a cause of tension, conflict, instability, and insecurity. In this case, relatively frequent changes at the level of the derivative myths, exempli gratia of conceptions and not of concepts, should only be negative. Therefore, the conception of justice as stability is a derivative myth that would be good to hold firm. Some master myths are clusters, closely integrated with myths, similar to mythems, in the same ways as constellations. So, for example, the American Dream, a complex assembly of auxiliary myths such as freedom, property, equality, individualism, competition, entrepreneurship, merit, and so on. Other clusters are the myth of the chosen people of Israel, the Republican France, the myth of ethnic identity as belonging to a symbolic order. These myths, like all master myths, are renewed from time to time in the form of derivative myths, which reproduce in their own modalities the structure of an aggregate. I think the idea that myths have a mutually positive function is plausible. It rarely happens that a myth is so powerful as to have repercussions on others in a synergistic way. In this case, Bouchard talks about archimyth. A sort of myth with an archetypal structure. This would work on a larger scale than the aggregate myths as clusters. However, the distinction proposed by Bouchard between archimyths, aggregate myths, master and derivative myths are very refined and they also sound appropriate. Sounds to me appropriate. However, a doubt remains. Faced with a myth without other specifications, it is not clear what tools give the interpreter security to make a sufficiently objective classification. In this sense, the motto invoked by Bouchard, "Masters in our own house," about archimyth that took shape in Quebec at the time of the Quiet Revolution, reminds us perhaps too much of the motto adopted by the Northern League, the Italian Northern League, Lega Nord, "Masters in our house." In opposition to archimyths, and antinomous situations can arise. Cultural minorities in the Americas works in the opposite direction of the myth of the Reconquest. Another famous example is Israel, currently divided between its globalizing and secular aspiration and its identity as the chosen people. And finally, the last case recalled by Bouchard is that of conflation. confluence, fusion of the new in the old social myths. He recalls the cases of sustainable development, of pluralism, ideals conveyed by globalization that have not been forged in the course of the Quebec past. This phenomenon can be observed in the recent history of many countries. And let's turn to the second part of my paper. A short one, anyway. Intra-historical nature of myth. So the second observation I can hold here concerns the so-called intra-historical nature of the myth. For the theory of social myths is in keeping with a critical revision of the dichotomy between primitive cultures and modern culture. If taken in a non-dynamic way, this dichotomy is unproductive because it postulates the existence of two radically different regimes that are difficult to identify for the purpose of a clear comparison. Rather, Bouchard invokes a general approach capable of highlighting social connection without reference to place, time, and discursive channels. In this sense, the myths are intra-historical. And for instance, the Italian novelist Cesare Pavese recalls how the myth has a normative structure, but does not consist in its poetic narration. It precedes, it is not the expression that it gives. The myth draws its value from this absolute uniqueness that lifts it out of time and consecrates it to revelation. Mircea Eliade wrote that the myth is, in this sense, an exemplary model passed down in sacred history, reveals a mystery. And in this sense, the sacred is the real par excellence. And let's turn to the third and last part of my paper. Societies as archetypal structures. So this consideration seems to me to be compatible with the idea that the structures of each society are archetypal structures, constant elements in the history of culture. And if so, the concept of law as a positive law, to me today seems a myth of modernity that in today's society, which we can also call technological, sounds like a legend of a very remote times. The positive law does not hold today to the test of the so-called technological society, but at the same time, it becomes necessary to turn towards those principles that can be registered in universal categories. If it is not possible to historically divide the principle of imputation, Germanzurechnung, from that of causality, it is possible and useful to preach of this principle, the universality. It is possible to grasp these universals by not remaining in a certain philosophical space, not in metaphysics, not in ontology, in phenomenology, but through them. So the scope, the goal of the telos of epistemological research today and tomorrow must therefore, in my opinion, go beyond the idea of positive law, overcoming the theoretical limit of legal positivism, placing itself beyond the peculiarity of the jus positum. But even without taboos, where everything and the opposite of everything seems possible. It is not, in fact, the single jus positum, rather the jus in civitate positum that we need to look at. Since it is not the contents of the individual positive law, of course, that give an explanation of the nature and the essence of the normative order. Such research cannot look at the transcendental forms of law. Universals are not born in Immanuel Kant from experience, nor are they placed in an a priori, prehistorical, foundational dimension. The categorical principles of law, as universal, are placed in an immanent and intra-historical dimension. We can call this archetypal dimension. The theory of positive law, working with historical categories, also comes to the elaboration of concepts and general principles, but in an imperfect manner. To arrive at the identification of the categorical principles of law, history must be kept in mind. Contain it without stopping at it. As we said at the beginning, it is necessary to put oneself in an intra-historical, transcultural dimension, being the universals independent of the singularities of the jus civitatis. And this is my conclusion. The categorical principles do not change with the change of history. They do not change with the changing of the regulations and the disciplines adopted from time to time. If on the one hand, there is no connection of dependence of universals with positive law, the opposite is given. In the positive law, to tie contingent eventualities to universals. In a sense, the legal subjectivity, which in a juridical relationship presupposes the subjective imputation of active and passive situations, is a universal. And the imputation as the responsibility of the acts individually ascribed to the individual, a categorical principle of law. On the other hand, universals are not the norms and the juridical rules that define the condition and the modalities of explication of the centers of imputation of such situations. This perspective allows us, maybe, to overcome the limits within which the interpretation of the pure theory of law, for instance, Kelsen's law theory, pure theory of law has been so wrapped up for a long time in a context that today seems to be mythological. Thank you.
Thank you very much for this very interesting presentation with a very interesting theoretical starting point, leading then to more concrete postulates for understanding law and the linkages to society. As explained at the beginning, we'll have questions in the end, so I'd like to hand the floor directly to Ekaterina Yahui, who is a senior lecturer at the Irish Centre for Human Rights, School of Law at the National University of Ireland. She will bring another philosophical dimension to our discussions and thoughts, and I think it links up both, to some extent, with both previous presentations. So I'm really looking forward to her additions to the debate. And she will be speaking about reason as the dark side of the law, a Leibnizian perspective. Ekaterina, the floor is yours.
Can I just ask you, because when I show slides, I know that I don't see time because it usually goes full screen. So 5 minutes before the end, I should be within that time, but just in case, because sometimes when I speak, I might speak more than I planned. So just give me a notice 5 minutes before the end.
I will do so.
Okay, so I'll start sharing screen because, oh, it says host disabled participant screen sharing. So I actually can share screen. Sorry, we didn't try before.
If you make her co-host, I don't know.
I did it, I changed it. The sharing, it should be
Okay,
possible.
now it should work. I see it now. Okay. So
Yeah.
Can you see now? Yeah. Okay. Yeah. So I should go full screen, maybe. I don't know. Do you see well, or should I do it full screen? Is it fine?
We can see it.
Yeah. Okay. So I'll go like that so I can see time. It's better. Okay. So the topic is here. I won't talk about topic, but what I want to say a few words about before I go into the details of the topic itself is why actually I talk about it. And today's two presentations actually connect to many of the reasons why I choose this topic, but also to the topic itself. And so we heard in the first presentation, for example, that the theory, legal theory, can be at the service of power. So we know that reason itself, like sort of a logical reasoning and scientific reasoning, legal reasoning, which we are so familiar from our education, is not enough to make good laws and to make just laws and so on. But the question then arises, what else is needed if reason itself is not sufficient? And so this connects to my interest in history and philosophy and my admiration for Leibniz. And I thought that his elaboration of the theory of justice and relationship between justice and law provides at least a beginning or opens sort of a conversation on this topic, can be very helpful in starting a reflection on this exact issue. So what I will do today is I will first of all talk a little bit about the concept of justice in Leibniz. Then, and this will be the major part of the presentation, because I think very often this concept is not understood the way I read it, and the way it helps actually to inform this very question of, if reason is not enough to have just laws, what is it that we need? And then I will talk a little bit about the relationship between law and justice in Leibniz, because I think this is also an important element in this conversation. And then just conclude with a few remarks on the lessons for contemporary debates. So when we talk about justice, in Leibniz, in his definition of justice, we maybe, those of you who came across his thought, one of the most famous expressions from Leibniz maybe is that justice is the charity of the wise, men or women, because usually they say in parentheses men, but let's say be inclusive, because he didn't limit it to men only. But what is important is, of course, that Leibniz wrote in Latin, French, German. He never wrote in English. So there are actually some problems with understanding his expression of justice as the charity of the wise through translation. And therefore, I have here also Latin side by side with English. A first important remark on this is, of course, that Leibniz distinguished very clearly right from law, in the same way in which we have this distinction, not in English, because in English right is only subjective rights, but as in German or French, and obviously in Latin, Recht opposed to Gesetz, or droit, loi in French, and jus and lex in Latin. But I will come to this distinction later on, because that's after. So what the first point is really to define justice and understand how he defines justice. Because in his definition of justice, there are two key terms which appear here. It's caritas and sapientes. So which is translated into English usually as charity and wise or wisdom. And there are several problems with it, because charity is in English is so a concept which is loaded so much with sort of Christian connotations and benevolence and so on. And that's not necessarily what Leibniz meant. So we need to delve into these two concepts of charity and wise or wisdom, how Leibniz understood them in order to fully understand his definition of justice. And so here, one thing I want to say already, because very often when we talk about Leibniz's definition of justice, what people also sometimes say is that it's a love of wise men, or love combined with wisdom, because this caritas is also translatable as love. And because I don't talk about this point on my next slide, where I go through these two terms, I want to say now just a few words about the meaning of this caritas as love in Latin, because again, sort of you who are familiar with Latin, you know there are many different terms for love in Latin. And of course, you know, amor, or like in Italian or French languages, you have this root. And this is love, which is affective, of course, but also sexual. So this is one meaning of love. But caritas, which is translated usually as charity, can also be translated as love, but this is a different type of love. It's a love, sort of kindness and understanding towards others. And that's very important, because that's exactly what Leibniz meant when because in his early elaborations of this definition of justice, he actually did use the term amor, or derivatives of verbs and so on. But then he abandoned it, and until his final years, he used the term caritas, not amor or derivative terms, because he precisely realized that actually this dimension of the meaning of caritas as kindness and understanding towards others is what we need in the definition of justice, not the love which is simply affection. That's not what he means. And there are obviously other terms for love in Latin, but they are not so important, so I'm not talking about them. And so, of course, it's very important to understand what actually Leibniz meant with all this terminology, and not just impose our own understanding of today's translation. Otherwise, we are going into the wrong direction. So here I talk a little bit more what Leibniz understood under wisdom, or this sapientis, caritas sapientis, and charity, or caritas. And actually what is good with Leibniz, you know, because he wrote on so many different topics, and for some topics he actually was very precise, and for others maybe less so, because he did not have time for them. But for this one, he actually did have time, and he provided a series of definitions, starting with like justice is a charity of the wise, then what is charity, what is wise, and he gave all the sort of sequences of definitions. So when he defined wisdom, he said that wisdom, it's not just any type of knowledge or reason, the way we might tend to understand it today. He said that wisdom is science of happiness. And then he said that happiness is a lasting joy. And joy is a state of pleasure where a feeling of pleasure is so great that the pain is unnoticeable. And then he said that pleasure is a sense of perfection which is related either to us or others. So you see that actually when he defines wisdom, it's not defined as an abstract type of reasoning, because he actually did work on many different topics in relation to reasoning procedures, and tried to even mathematize, for example, law. Like I'm not sure if you came across, but this sort of calculability of law was one of important preoccupations of Leibniz, especially in his early years. But he also tried to make calculable the whole reasoning process. However, here in defining justice, he also tries to be very precise in a sense that he does define this wisdom, this reasoning part, something which we usually would identify with reason, in terms which are not self-evident to us. And you see that actually the feelings, emotions already appear here as part of defining what it is to have a reasoning process here. So wisdom, what it is, wisdom, and what it means to be wise. So he did the same thing for charity. He defined charity as universal benevolence. Benevolence is defined as habit of love, or loving or willing the good. And then this habit of loving is defined as rejoicing in the happiness of others, or otherwise converting the happiness of another into one's own. And what is important here is, first of all, this charity as universal benevolence is a habit of loving, willing the good. And it's a habit. When he talked about habit, he said it's something which you can actually instill in people. It's not something we are born with. He never said that, for example, one misconception might be that people are inherently good or bad. Like Hobbes was saying that people are inherently have sort of negative tendencies in that state of nature, and Leibniz might be interpreted as, but he didn't say it, no. He said, you know, these all good, loving tendencies can be cultivated through education and other means. So habit is actually one of the key terms here. And this explains also, because we will come to the connection between justice and law, but it's also important why he spent so much time writing about education for lawyers. He has volumes of how legal education needs to be structured, and it's obviously not just about learning laws and interpreting laws. It's a lot about also other elements of knowledge, like metaphysics, for example, which today are not included in the legal curriculum. And another thing which is important here is it's not about sort of altruistic love for others, because he says here in this definition, when he talks about what is this habit of loving or willing the good, it's rejoicing in the happiness of others, or, and he explains, converting the happiness of others in our own, because he understands that people are to some extent egoistic. They prefer their own good before they prefer the good of the other. So he says there's a possibility to convert this good of the other into your own pleasure. And this is again something which needs to be cultivated. But in order to understand his idea, one example he gives is our pleasure for music produced by others, or for painting, sort of artistic enjoyment of works of nature, for example. He said that in the same way in which we enjoy, for example, arts or nature, we can enjoy when we see that other people are feeling good and are sort of living well, for example. So what another important point from this discussion is that justice as the charity of the wise usually is said to be constituted of reason element and affection element, which is love. I argue, and I will show it on my next slide, that it actually more than that. There are three elements, and so I will go to my next slide then here. We have, first of all, knowledge defined in very specific ways through wisdom, so it's not simply reason. Action, which is charity, because remember, charity starts with benevolence, with habit, with action, it's action. And then, if you, on my previous slide, I highlighted happiness here and here, because it appears in both definitions of the charity and wisdom. And actually, this is the affective element which unites knowledge and action. And all these three elements inform each other and allow for this achievement of this justice as the charity of the wise, as something which can bring about a good, let's say, in the for humans in societies. Of course, very important question is, of course, we have this very beautiful definition of justice. How do we go about in making it real? So he was also, I don't think he provided full answers to all those questions, because especially towards the end of his life, when he came up with this definition of justice, he actually did not have time to dedicate to, he had other projects because he was on service of some, he was a servant to politicians, and of course other priorities took over, and he did not complete many of his projects, unfortunately. I find it really unfortunate. I'm very passionate about his thought. But he did say certain things about the relationship between law and justice, which keep to clarify some of the questions which might arise. Okay, you have this definition, what would you do with it in real life? And the starting point to understand his position on this is, I reproduce here his quotes from 2 different works. But what he says is that when we have law, it's because we have power which maintains this law. And this law can be just or can be unjust. He was a very realistic man because he worked with politicians, rulers of his time. And he said, if this power lacks wisdom in his definition, and goodwill, remember it's all in the definition, then of course laws will not be just. But what is needed in his opinion, and this I don't have time to talk about it in detail because he did elaborate on this, is that power holders, if they don't have themselves this wisdom and goodwill, they have to have counselors or advisors who will then be able to bring this element of wisdom, and again, wisdom in his definition. Because very important to understand, wisdom for him is not just innate reason. That's something, it's very different. And then we can have laws which reflect precepts of justice. There's another element in his reasoning for which I don't have time, on which he worked, and again, he did not complete it fully, but he did believe that there are sort of precepts of justice which are like mathematical truths, like mathematical theorems, for example. They are true everywhere. He believed there are certain elements about justice which we can discover through certain reasoning procedures, and then these elements can be made positive law, taking into account realities within societies and so on. So it's not like you just take some concrete rule which will then tell you what you need to write in your code. Of course, that's not as simple as that. But he still believed, and here I was reminded about these thoughts of Leibniz when in the previous presentation, Fabrizio was talking about universals or categorical principles. It's something similar, but I think Leibniz was more precise on this still. Anyways, but that's something like that. If it helps you thinking in these terms, you have certain principles which are universal, which are true at all times, at all places, but then you need to discover them first. And second, you need to have this support of rulers and people in power in order to make these rules part of functioning human communities. And for him, it was possible. It was very complicated. It also included very important work in relation to education of lawyers, for example, who are those very important people in the process of translating precepts of justice into positive law. But that's like sort of, he thought about all this, although not maybe didn't complete his thought on all of those elements. And so what I have here is another just sort of clarification element to his vision of positive law as a question of fact, because when we look at laws, we are just looking at facts. We are not looking at justice, and then we can evaluate these laws, whether they conform to precepts of justice or not. And question of justice of natural law is really a scientific question for him, and sort of is a more difficult one to answer. So where does it bring us to in terms of today's questions? I already connected it a little bit, but what I want to tell you about, because I said in my title, reason as the dark side of law, very often when we talk about law today, we talk about law as reasonable, objective, neutral, and so on, all this terminology. And At the same time, of course, today we criticize law, and there's a lot of critical legal studies and other strands of legal thought which will say, oh, law is not objective, it's purely subjective, and criticize it also justifiably for being actually expression of preferences of certain people and thus being subjective. However, what Leibniz teaches us is that both sides are not entirely correct, because there's no such dichotomy between objectivity and subjectivity of law. In order to be wise, law has to incorporate correctly in his interpretation all these affective or subjective elements. When he talks also about this habit of loving and cultivating all these good affective elements, because that's another difficulty with his project, is that of course he singles out some positive affective elements which needs to be part of justice and therefore of law, and therefore complicate this distinction between objectivity and subjectivity. But he understands that there are also negative affections, negative emotions which people can have. And that's a key point in his definition, where he says it's a habit which we need to cultivate, because otherwise people will use negative emotions. But for contemporary debate, I think it's very important to get rid of this dichotomy between objective and subjective, because reason itself, objectivity itself, neutrality itself doesn't bring us anything. And criticizing all things as subjective also doesn't bring us anywhere. So what are key points and key questions to ask today is about the role of emotion in rational thought. And this is something which is developing in psychology, anthropology, neuroscience. Of course, we have today this strand of law and emotion, which is developing and which is trying to understand what role emotions play or should play in legal reasoning and in law in general. But I think we need to go further. And once we have all this knowledge about the role of emotion in rational thought, then we need to ask questions which Leibniz actually tried to ask during his time, about how do we go about and making our law more just, and making these positive affections, which we identify as positive for, let's say, common good, let's say, part of functioning legal systems. So he provided some elements of answers which can help us. And he also provides sort of a direction how we can think about it. That's what I find useful in his thought. You don't have to agree with him on all the points, but I think trying to understand how he thought about these processes and maybe provide different answers at the other stages of this process is very important, and can help us to move away of thinking about law just in terms of objectivity versus subjectivity or reason versus passion, and break down this binary and have a more complex conversation. So I'll stop here. Thank you very much.
Thank you very much for, again, a very interesting contribution. I think you brought to our attention a dimension and ways with dealing with the dimension of law that is, as you said, generally under-evaluated, though there are tendencies to do with that. So thank you very much. I would like to now open the floor for any questions and comments, if there are, to any of the speakers. Rostam.
Thank you, Lucas. If I may, I would just like to continue on the last presentation, which I found very interesting. So I would like to ask Ekaterina, if possible, about Leibniz. I don't remember too much about Leibniz, but what I remember having come across is that he's also considered the father of computer science, actually, because he has in a way helped to design this 0-1 binary system that computers are using, which he apparently also took inspiration from the Chinese I Ching, which is this hexagram of 64 symbols of weak and strong, another dichotomy. And there I would like to ask you, is there anything in his work, or what do you think actually concerning logic, because we very often, of course, we juxtapose or oppose reason and emotions, but even within reason, we can distinguish an exclusive logic, which would be the Aristotelian, versus the fuzzy logic, that would be more the Confucian way of looking at things, that things can be just and unjust at the same time. So what do you think did he mean, or especially when we look at computers today, because I think quantum computers are now also going to work more with both 0 and 1 at the same time, and no longer either or, jumping from one to the other. So is there anything in his work, or what are your thoughts on the logic that he applied, or that we should apply today when reasoning in law, or trying to find justice, like you said, to find truth and justice maybe through reason? Do you have an answer for that? Thank you.
Should I answer now, or do? Yeah, okay. So first of all, of course, he worked a lot on logic, and you are right to remember his contribution. Like it's very interesting to read his books and certain things today about this artificial intelligence, and what he tried to do, and that's my reading of his work, basically, that he tried to systematize knowledge as much as possible, so that it can be reduced to a number of very simple operations, and therefore sort of very much like computers today. But of course, for the binaries, he did what, like, the problem with Leibniz is that there's one thing, the way his thought worked in his early years, where he was really persuaded as a young student, very young, because he did his PhD at very young age. And during this period, he was really persuaded that you can bring law down to calculations. And in that sense, I think at this period, he can be still said to be in this binary logic. Whereas if you look at his later years, what is happening is that he's more focused on trying to collect knowledge and systematize it, give clear definitions, so that we have connections and relationships between these different concepts with which we operate. So I would say in the later years, he does move away a little bit from that simplicity of the binary. And he is focused, and if you heard about his monadology, it's really all about relationships, about the complexity of our world. But the problem is, as I said, that he was not able to complete many of his projects. And so my interpretation is that, yes, he can be very helpful also in this next step, which we are having now with the artificial intelligence and so on, and including with the law, whereby you don't think simply in exclusionary terms, but in more complex relational terms about things. So that's my vision of his. But again, it's very important to distinguish his early years from his late period in this sense.
Thank you. Are there any other questions?
Hey, just say something about, sorry,
Sure, go ahead.
Congratulations to the other two speakers. I just wanted to mention, because Lucas, you said that I am a judge too. I'm not really a judge. This being a member of the Supreme Specific Court is about cases where there are opposite decisions of the Supreme Court and of the Conseil d'État, the Greek Conseil d'État. So we are professors, we are elected for a period of 2 years. It's an honor and a great responsibility, of course. It's my second year. That's, so I don't really have a practice, a view from practice. Okay, just that.
Lucas, maybe I
Yes,
can ask
sure.
my question that I asked Elena in the chat box. And that is about, I mean, coming from a post-colonial country as well, and the it is often said that it would have been different if it was not for colonialism, and it would have been better. But I'm not so sure that colonialism has always been negative for the development of a country. If you consider and I'm talking about an African context, if you consider countries such as Ethiopia, where which was not colonized, I mean, if you look at the development there, it's also socio-economic challenges in certain aspects, even more than South Africa. So, and India as well. I mean, India is really depressing. Going to India, I also did my PhD research in India, and I must say I was in a constant state of feeling, oh my gosh, can it ever be salvaged, the socioeconomic circumstances in India? And I think it's even worse than I was there when I did my research. So how can we say that it would have been better if it was not for colonialism in a country? Because I mean, if you look at historical developments of countries where there was no colonialism, the situation is the same. I don't know how to, the views on that. I mean, I will be stoned if I say that in South Africa, because colonialism is everything bad. And some politicians who have said that the opposite, that it was also good because infrastructure developed in South Africa because of colonialism. If it was not for that, the infrastructure in South Africa would have been much worse. So I'm not so sure that colonialism is always bad for the historical development or for the current situation in which a country is.
May I answer?
Yes, please, go ahead. Yeah.
Okay. Thank you, Krista. This question, this topic really haunts me since many years, and it will still be haunting me the years to come, I suppose. So I don't, as I said, I don't have an answer. I am searching. I'm not saying for anything that it has no, that it's only negative. Colonialism may have good results, and I don't like this phrase of mine. I hate the violence that colonialism had as a consequence, of course. We cannot show, it's not a matter of some years, so we cannot say what if. We cannot have evidence about that. But it is not a simple question, because we do have circumstances today that have been created by the big powers of today, who are big powers of the past, and they directed somehow the world towards this, towards what we have today. So I don't know how it would be. Obviously, so many people would not have been killed, would not have been poor. Adam Smith had written about the history of India, that the East India's company, for example, had changed the everything about the trade and everything, so it caused the death because of starving of 1,500,000 people, so something like that. It's horrible. So we cannot change the past. We cannot correct the past. We cannot have real answers. African countries had suffered so much. They changed, they gained their independence, but in circumstances that were not so really heavenly. I mean, they were forced to follow examples, to keep their official languages, of the ex-colonizers, to follow the rules, because many people too were, I don't know, had also, some of their people had also the will of power. So I don't know, the fact that many industries used, for example, the soil, the water and everything, so they everything had a cause and everything had a consequence. So what would have been if there was no colonization? I cannot have the answer. I have them, but I really am sorry for what so many people suffered. All this slave trade would not have happened. I mean, it's monstrous. It's almost 400, not almost, it's 400 years old, I think. Yeah, since they first were gone to Caribbean. I mean, and we have the consequences now of what happened so many years before. So it's not easy to have an answer, but I could not say either that colonialism was good. Every situation has, as I said at the beginning, positive aspects too. It depends on the people. It depends on the circumstances. That's all I can say now. But I'm still searching. Yeah, thank you.
Rostam, you have a comment or question?
Yeah, if I may just add here, if I may rephrase this discourse and ask you, like, from the study of the injustice coming with these colonial laws, like what can we learn for today, like in terms of which laws do you think could be considered to be considered unjust in 20 years? Like, we can think of, for example, simply the classification of gender. In Austria and in Germany, the constitutional courts held now that actually the third gender should also be considered, like, and which means that this binary system of male female is unjust. We can also think about maybe certain tax laws are highly unjust in a sense. If we read in the news today that maybe super rich people pay 0.1% tax, whereas like a normal person pays 50%, a corporation only 20%. What about robots? So I mean, are there any, from your interesting like analysis, can we learn which laws we should like closely scrutinize now, because they are already or will soon be outdated and considered probably also colonial in a sense, in a wider sense? Do you have any answer to that? Sorry.
Yeah. Oh no, that's a very good. That's a very nice question and very interesting question. I'm really like the critical legal studies. I have objections. I'm not sure about the answers because a law to say in a definite way which law would be just, that would be too arrogant from my side. I think. I mean, every law is adapted to the situation in each country. That's what we comparativists say. But each law can be the result of many many hidden procedures, probably, or it can influence in a positive or a negative way. It cannot be adapted to the interests of the rich. So I think that there is not a universal law that could be. I would never say that that there should be a universal law for all countries. That would be rejecting my.
But what about the Universal Declaration of Human Rights? It's universal.
Yes, I know what you mean, but I have a point there, because I often say that to my students. I don't believe let me rephrase it. The fact that some countries, or many countries, have not, for example, signed the Convention for Human Rights does not mean that they do not respect human rights. That's something European. That's something that was created in Europe. And of course, it represents very good ideas. How do these good ideas are realized in praxis? I don't know, but let's not be severe with all those people who have not signed the convention or have not they're not the members of that of treaties or covenants which say those things. I'm a European. I'm not. Although I don't believe in one European civilization or culture, I believe that it's much richer than that. So obviously, I'm already influenced. Is there an objective view of law? I would say I would adopt the title of a lecture of Pierre Legrand, who would say, "My foreign law." So my thought, what I understand of one or more foreign laws. So I don't really believe that there is one and only right answer, because who would I to be to say something like that? That would be arrogant, I think.
There's yes? Alessandra Pera had a question, but before letting her speak, I just like to take up the discussion and hand it to Fabrizio, because we started talking about universalism, and I think that ties in nicely to your conclusions, at least as I understood. So how would you see this discussion around universalism ties into your thoughts? Maybe you could elaborate, and then Alessandro,
okay.
Because actually my question is to Fabrizio, and is to connect Fabrizio and Elina. So
okay,
probably
so go ahead and ask before he answers.
Yes, because I was thinking that last Elina's words and Fabrizio's starting words are connected in a certain way also to Rostam's last question. I think that, and I would like to ask to Fabrizio, because I think that there is a huge debate on the idea that some human rights or universal human rights and the debate on them is in a certain way culturally oriented, and it was built at its beginning from a Western legal tradition perspective. And in this sense, I agree with Elina, because there are some fundamental values that are common, but are really conceived and decline in every single legal system or experience or tradition, whatever you want to call, in very different ways. So let's think about the value of life, for example, which is saint in a certain way, which is sacred, but it's in some critical paths, such as abortion, or such as also the idea of people who sacrifice their life. I think about religious tradition, on the behalf of something which is perceived as superior. Let's think about the extreme version of jihad. So even if we look at life as a value, as a law, as a juridical good in a certain way, we can have many different experiences. So I would like to ask both Elina and Alessio how they perceive and how they feel about this cultural oriented building of fundamental human rights and values.
Please, Fabrizio.
Already,
okay. Already answered.
Yes,
afterwards.
yes, thank you. It's a tricky question. I think that human rights are fundamentally cultural values. And I agree with Elina, holding that, yeah, human rights are just a point of view, as a vision of the world, no, Western vision of the world, which causes conflicts and cultural conflicts. So human rights appear to me quite distant from natural rights or Leibnizian natural rights, which descend from reason. While human rights, on the other hand, are, yeah, political ways of solve negotiations, and not rights in a philosophical sense, nor in a legal sense, maybe. Look at the Declaration of the Human Rights, 1948. The preamble is just a sort of declaration of intents, not a positive law norms. And I agree with Robert Alexis' perspective, Theorie der Grundrechte, when he says that, yeah, the difficulty of rights, of fundamental rights, has a lot to do with their application. And I think that human rights are fundamentally a matter of application. So universals are categories, on my view, but universal rights are something different. Universal rights intended as human rights. Human rights in this sense are not universal, are something you can share, maybe, if you want. This is my point of view.
And how does that link with your presentation on universal, thinking about law in universal terms? I think I'm shortcutting a lot, I know, but I would be interested to hear you also on how that links to your presentation and your thoughts on laws.
Okay. Yes. So I think that categorical principle, in my presentation, I try to hold that categorical principles of law are universal. Why? Because they are embedded in a sort of intra-historical dimension. So, and this dimension is archetypal, because it's made of rules, of general rules, which have a lot to do with human behavior, and not with positive law rules. Positive law are, of course, cultural products of zeitgeist, maybe, or something like that. So in this sense, I think that the categorical principles of law maybe are not captured in the positive law norms, because they are something transcendental. Universals are not, are sort of Jura connata, Kant says, so are not something positive, something which is positum in the Latin language. So this is, I think, this is the connection I can see in my with my presentation.
Rostam and then Elina. Yeah.
Yes, please, Rostam.
Okay.
Yeah.
Sorry, no, just briefly, connecting this also, like, unfortunately, Katharina left, but my question regarding logic is related to that. I wanted to ask Fabrizio also, like, I remember the Austrian psychoanalyst Otto Rank wrote in a book about the birth of the hero that the collective, the mythologies are in a way the result of the mass streams of individuals, of all people. And I compare, I think, the question of the universality of law or human rights also in a way to this. And what we are lacking here is the right logic in terms of seeing that the only way, in my view, that makes us truly or is the basis for laws to be universal is the fact that we are all equal in one thing, in being different. We're all unique. And here, I think we need to bridge these dichotomies of the individual dream and the mass dreams, or the individual law and the universal law collectively applicable. And I think also from my life experiences also in Asia and elsewhere, I don't think we are that different in these fundamental ways again. Like apart from the fact that we are all the same because we are different. So I think we need to adapt our thinking to the interpretation of these, and I think there is still enough evidence to pursue the goal of the universality of laws and human rights, and make it best, most suitable to everyone, if possible.
Elina?
Okay, thank you. And thank you, Alessandra, for the question, and everyone. Yeah, it's so interesting. I believe in influences. I believe in influences, so I cannot deny the influences. And that is, to my opinion, the reason for all the results that we have in laws too. So we are humans, we have common, we have many similarities as humans. Justice is one, is the aim, but perhaps we are reaching to that aim with different means. And in Asia, they're much more influenced by a specific, it's too much to say Asia has many influences too, but in China, for example, Confucius had a tremendous influence. I admire them for that, and for keeping that influence after so 2,500 years. In Western world, things were different, and especially that's why I am haunted by colonialism, because things were went a certain way. So richness was in their hands. That richness helped create good things, of course, universities, augment cultural institutions. So it is, so poorness, on the other hand, influenced people in other ways. But I could not elaborate on that because I would need hours or days. Or I do believe that it's culturally influenced, or everything is culturally directed or influenced. But I don't believe in this respect, of course. Condorcet, who was one of the Enlightenment big persons, who was saying that okay, we are civilized and the others are not. So we have a debt to civilize them, and if they do not want it, we will civilize them by violence. So it's not really something to respect, an idea to respect, but it is not very, it's not really known to many people. So cultures, I believe in what Claude Lévi-Strauss had said, that all cultures have the same elements, but they mix them different ways in order to adapt to different situations. So respect is the answer, and trying to understand the why of each country's or each community's situation and law and the law, and not impose on them laws or institutions that we believe they should have, because this way we show arrogance, and we believe it means that we believe that we are the best, so the others, the poor others, are not. Yeah, that's my answer. Thank you.
Thank you. Unfortunately, I do think that we have to end the discussion here. We're already 15 minutes behind schedule, but I think it was really worth it. It was fascinating. I think we heard the presentation linking law comparatively to power, abuse of power. We heard Fabrizio linking law to myth, collective imagination, and then we heard Katerina, who already had to leave, who linked or who made a point in pleading for linking law more consciously to love and emotion. I think we really had an interesting overview on different ways to see law. And I think those perspectives we might take them with us in our further comparative endeavors. Thank you again to everyone for your thoughts, your questions, your responses, and I'm looking forward to continuing the discussion in the upcoming sessions.
Thank you. It was very rich. Yeah, thank you.
Thank you.
Thank you very much.
Bye. Till later.